Good afternoon, everyone, and welcome to today's webinar. My name is Irina Bobrova, and I'll be your host for today. I hope you enjoyed your very generous 1 week of rest after tax season, because today we are rolling up our sleeves and going back to work. And not just any work. We have about 2.5 months left on the clock for Kwong. And this is not just an opportunity. This is a money-making window. Before we jump in, some housekeeping. Stay with me because it does matter. This session will run for 1 hour. CPAs and enrolled agents will earn 1 CE credit. There will be 5 polling questions. To qualify, you need to stay for the entire session and answer at least 3 polling questions. The session is being recorded, but CE credit requires live attendance. We also have Q&A section, so drop your questions in as we go, and we'll try to answer all of them during the session or live at the end. Under Resources section, you can find handouts for today's presentation. Today's speakers from Frost Law will show you who qualifies under Kwong, how much can be abated or refunded, and how to actually submit a claim. And one more thing, at Biddable Tax Software, we've already done our part. Now you can see on your transcript dashboard exactly which clients qualify and how much is on the table. No guesswork, just opportunities. So now the question is, how much of it are you going to capture? Before we jump into presentation, I'm going to launch our first polling question. Few seconds. That's really easy. What's your professional designation? Okay, and now without any further ado, please join me welcoming Glenn Frost, Managing Partner at Frost Law, Alyssa Malouf-Watley, Director, and Sadler Graham, Chief Revenue Officer. Glenn, Alyssa, Sadler, the floor is yours.
All right. Well, thank you, Irina. We really appreciate it. And we're actually super excited about your tool. We used another service and doesn't quite have the same level of detail that the tool in Pitball has. So I highly encourage everyone to absolutely use this tool, download it. We want to see as many clients as possible benefit from it. But so my name is Glenn Frost. I'm a tax attorney and CPA and have a tax controversy practice. We have a law firm based in Maryland called Frost Law, as well as a law firm based in Arizona called Frost Law AZ. So we're excited today. I'm joined by Alyssa and Sadler Graham. And Alyssa, to you.
Okay, so I am going to sail past the my bio here. I'm a bankruptcy and tax attorney. I specialize in tax controversy cases, primarily collection cases. I'm also on the co-chair of the ABA section for tax workouts and collections and insolvency. So I think there's a lot of opportunity here, not just for taxpayers that may have refund claims, but people that have abatement claims as well. So we're going to get into all that. Sadler, do you want to introduce yourself real quickly before we get into the meat of the presentation?
Yeah, absolutely. Thanks for the intro. My name's Sadler Graham. I'm the CRO at Frost Law Arizona. My background is primarily helping small to medium and large businesses recover monies that they may not realize that they're entitled to. All of us on the call kind of serve in that mission, and Kwong is a fantastic opportunity to continue to go and bring value to clients in this space.
Awesome. So let's get into what the holding was in Kwong and what the issue was. So basically, the issue was 7508 AD mandated an automatic extension of tax filing deadlines during a federally declared disaster area, or a federally declared disaster, which in this case, what we're discussing is COVID-19. So the court held that the 2019 version of the statute mandated a suspension of the deadline for the entire duration of COVID-19 plus 60 days. Now, the taxpayer's attorney in this case was the one making that argument, and the government was trying to make a different argument. And so this is where Loper Bright, if you're not an attorney, the Chevron doctrine, the court didn't give any deference to the IRS's interpretation of that ruling. So the IRS, we'll cover the statutory language first, which is the court ruled that it shall be disregarded, right? And whether that is mandatory or discretionary. And so the services position was the extension authority was discretionary and it was only limited to this 1 year because of these Treasury regs, right? And so that's where the Chevron doctrine prior to Loper Bright used to say, well, where there are things that are unclear in the law, we would normally rely on that agency's interpretation, right? But in this case, they decided that the statute's too unambiguous, and once a disaster was declared, the postponement is mandatory, and it operates by a force of law. So the court basically disregarded the IRS's limited interpretation that was only to 1 year and stated that it was mandatory, that it was the full postponement window. So what is that window? Well, the window, according to the Kwong court, started on January 20th of 2020, which was the earliest incident date for COVID-19, and it didn't end until July 10th of 2023, which is 60 days after the end of the disaster on May 11th of 2023. So what does this mean for your taxpayers, or what does it mean for taxpayers in general? Well, the result of this is that any deadline for filing a tax return, paying a tax, or filing a refund suit fell within this window was automatically postponed July 10th of 2023, right? And so the impact here is the IRS may have improperly, under this ruling, which we're going to discuss what's going to happen with the service and the government, is that anybody that had late filing or late payment penalties or accruals of interest during this postponement window may have been improperly assessed. And if they paid that amount, they may be entitled to a refund. And if they haven't paid that amount, they may be entitled to an abatement, right? And so this has pretty significant impact. And we're going to talk about, you can see how the impact changes over time. So what does it apply to? Well, we kind of just talked about that. We put it in multiple categories, but it's going to encompass general failure to file, failure to pay, right? Failure to deposit, underpayment of estimated tax payments, underpayment of interest accruals, informational return penalties, and international reporting penalties, and excise tax and compliance, like the ACA shared responsibility, and retirement account excise taxes. So it can extend far. And we're also going to talk about, to me personally, I think it's very simple to make the argument that it clearly applies to 19, 20, 21, and 22. And then there may be extended Kwong arguments that you can make about interest accruals during that period, not within that window. So there's a lot of different arguments that are being made. And Irina did all the hard work in helping y'all figure out where the claims are. And then she even pulled out ones where the law is not so clear, but there are law firms and people making the arguments. And so she kind of pulled that out for you, which we'll look at in one of the transcript reports. So Pipple has done a really great job of helping practitioners identify their claims. As somebody who has, I don't know, I think I have 300 clients under my firm before I merged my firm into Frost. At Frost, we've got like 6,000 clients. And now I'm thinking, right, even people that aren't in your inventory, I close out so many cases every year. I'm thinking, oh my God, who paid off their taxes? Who do I need to contact and let them know that they may be entitled to a refund for this? So not only thinking about the people in your inventory that you already have Pitbull access for, that you already have their transcripts for, you also need to be thinking about who you've closed out lately or in the past few years, who this could have a significant impact on. For some of my cases, I'm seeing, $50,000, $60,000. But for some of my larger cases, like I have many, many people that owe a lot of money. I've got one taxpayer that owes $10 million of payroll tax. We're looking at an abatement request, right? And the interest and penalties is about $2 million. Or I have a celebrity rapper case that owes $3 million, and his Kwong abatement, because there's not going to be a refund because he still owes the money, right, is around $1 million. So whether or not Kwong holds up or not, it is worth it for us to attempt to preserve their rights. And we'll talk about the deadlines. But as far as the failure to file, right? So failure to file is 5% per month up to 25%, eventually caps out, right? So you can see kind of before the July 11th of 20, and we're going to do examples. So you don't have to worry about, see, I think it's easy when you explain the examples, but before July 11th of 2023, if they filed 19, 20, 21, or 22 within that time frame, there would be no penalty because it would be considered timely, right? Between July 12th and August 11th of 23, then it's 5%, then it's 10%, then it's 15%, then it's 20%. And then after December 11th of 2023, they've already hit the 2020, they've already hit the 25%. So how much savings each individual taxpayer has is obviously based on when they filed, when they paid, and if they paid, right? And so that's why the transcripts matter so much. But again, Pitbull already creating this dashboard for you kind of makes it easy so you don't have to figure out, okay, who's got savings, who doesn't. It's already on your transcript report and you can already access that information and kind of reach out to your clients to see who would like you to do this on their behalf. And I do feel like if you're representing people and they have a controversy issue, it's something that you need to bring up to every client if they have a claim. So let's get into the failure to pay.
And
Obviously, you want to
sorry,
add
real
something?
quick.
Yeah.
The poll here, I think really helpful to understand. We're talking about a complex subject and we're going to make it simple, but would love to understand the audience's familiarity with this topic. So, a poll was just launched. You should see it on screen. How familiar are you with Kwong versus the United States? Options are I've never heard of it, but don't know much of the details, reasonably familiar, and some of the experts out there. That poll has been launched. You should have the ability to make your selections now. We'll give you a moment, and while you're taking the time to answer those questions, I think the takeaway, and as we get into the substance of this, is the government, they're not going out of their way to correct these mistakes. They're not saying, whoopsie, our fault, here's the money back, and or here's a reduction in what you owe. It's the practitioners that support these taxpayers that need to make it happen for them. So I just want to set that as the stage. Big opportunity, help is needed. We're going to educate you on what that looks like.
Thank you, Sadler.
And of course, does the poll results, do they populate on your end? I'd be very
Yes.
interested to see.
You see results? Okay, give me a second. I'll share.
Yeah. Okay. 10% of the audience is experts. That's fantastic. 23% reasonably familiar. For those who have heard of it or haven't at all, we don't fault you. It's hard to keep up with daily activities as it is. The courts are making decisions far too often and they impact your clients frequently. So no matter how you fit in with your level of understanding, we will get you proficient. You will leave here with the ability to bring value to your clients. And the hope is, as we unite together to serve our clients, we're going to be able to make meaningful impacts for them. Awesome. Thanks so much. Alyssa, I'm going to turn it back to you.
Great. Yeah. So I think that's a really good point. And we're going to go, like I said, we're going to go through the examples and what we're seeing. Because I have tax court cases that I've already raised this issue in. I have CDPs that I'm raising this issue in. Emailed them to the service center. Haven't heard back about those, but we'll go over all of that. The math on failure to pay, it's 0.5% per month. Again, has a cap at 25%. And so this is just showing you the number of months, right? And the savings or the failure to pay penalty. So you can see 19 is obviously the year that generally is going to have the biggest savings, and 2020, 21, 22, depending on, right, the amount of tax that was due or when they filed or when they paid. All of those things are so specific to individual taxpayers, and that's why the transcripts are important. You know, when I post a lot on social media and I've put a lot out there about this case, and people are like, well, what are my Kwong savings? And you're like, well, it depends on your transcripts, right? It depends on your facts, friend. And the facts are all of the details are in the transcript. So um, having that data again available that made easily, you know, to pick out and identify with Pitbull is such a blessing. And especially when there's such a short window of opportunity here for actual refund claims. So I'm going to continue on here. This is showing you the interest on the math, right? So basically, like we said, if it fell within that COVID window, January 20th of 2020 to July 11th of 2023, there should have been no interest charged on the taxpayer's account. Obviously, the interest would start accruing after that July 11th date, and you know it's the short-term Fed rate plus 3%. It changes every quarter. So basically, when you're doing a Kwong analysis, you're trying to figure out, which again she's already got there for you, what the difference in what they were charged versus what they should have been charged under Kwong, and whatever that delta is, that is the amount of the claim, right? So we gave you a little example here. I think having examples as a practitioner to me is always super helpful. So for this one, again, we're just going to go through this. If the taxpayer owed $100,000 on April 15th, but they didn't pay it until July 1st of 2023, right? That's still well within the Kwong deadline. So normally they would have had the failure to pay penalty plus the underpayment of interest. And so they would have paid, 137,000 under, without the Kwong analysis. Now under Kwong, right, there's no failure to pay, right? Because the deadline's been moved and they paid it within that deadline. And therefore there should be no interest accruals either. And so they should have only paid 100,000, right? And so that is the difference between the two. So this person, if they obviously paid the tax, this is a straight refund claim, right? And it's $37,000. Now, most of us are dealing with people that owe back taxes, right? So even if they get this Kwong abatement, that money may be offset to a different tax period. And so I had some practitioners on my LinkedIn say, okay, Alyssa, who cares, right? Like if they owe back taxes, why should we even file a Kwong claim if their government's just going to offset it to a different tax period? I mean, it's the same reasoning as why would I do FTA? Because obviously it helps the taxpayer out. And if we file the claim timely and Kwong holds up, it's a 50-50 shot, right? That the court upholds Kwong. And why wouldn't you do it? I just don't understand why we wouldn't be helping these taxpayers out, getting the claims filed, preserving their rights. And if Kwong holds up, hopefully the refund does get issued. And again, in a back tax case, then that gets moved to a different period and then makes whatever resolution we're doing for them even more affordable, right? So I don't think there's any harm. I was surprised that some people are like, well, it doesn't really matter. I think I'm just going to leave it alone because they owe back taxes anyways. I don't think that's the right, in my personal belief, I don't think that's the right thing to do. I think if they've got a great claim, there's no reason to get it filed whether they owe back taxes or they don't. All right, so example number 2. A restaurant had a payroll tax bill. So again, this also applies to 941. So I was just giving you an example of my client that owes $10 million and has $2 million of interest and penalties, primarily during the Kwong period because his liabilities are generally 2020, 2021, I think in 2019. So let's pretend they had a $250,000 bill that was due on July 31st of 2021. And again, due to the pandemic, they didn't pay it until December 15th of 2022. Again, we're still within that Kwong window because the Kwong window is January 20th of 2020 to July 11th of 2023, right? So it's well within the deadline and they paid it, right, well within the deadline. So we're not going to have any failure to deposit penalty or any underpayment an underpayment of interest penalty. So you can see the savings here. Again, it's the delta. What were they charged? What should have they been charged if Kwong holds up, or what the Kwong period is and what the net difference is there, which is $40,000. So again, that's significant savings to, any taxpayer or any business owner. Um, I joke around, my Kwong savings was like $228, but I'm a tax lawyer and I file and pay on time. So there it is. So
You
let's
shouldn't
do.
pay penalties at all, Alyssa. Come
I
on.
know. Hey, you know what? I'm one of those people that I like to make my estimated payment in Q4. I hold on to my money and I'm playing with my money. That's what I do, even though I know it's wrong. That's
Just
what I do.
kidding. Okay.
I admit it. I'm a Q4 payer. Um, so let's get into example number 3. It was one time. Let's get into example number 3. Imagine a business with $500,000 of income tax liability for 2020. And obviously that would be due on April 15th of 21. And so due to the pandemic, right? And again, they don't have to say a reason. So let me be clear. I don't want to make You don't have to say, oh, I was impacted by COVID-19 or anything like that. It's not like you have to use COVID as your reason. It is mandatory, saying by law, that tax filing and payment deadlines were moved, full stop, right? So I don't want anyone to think that they have to, I know we put that on there, but you don't have to put COVID as your reasoning, right? The law is the reasoning why they're not paying the interest and penalties, right? So they didn't file or pay until October 15th of 2020. So again, we have the two segments here, right? So under the original treatment, their total bill would have been 705,000, but under Kwong, there's no failure to file penalty, there's no underpayment of interest penalty, and they should have only paid 500,000. Now this person has a $205,000 Kwong claim. And again, if they don't owe back taxes, that is a straight refund claim that could be paid out to them under this ruling. And that's the important thing about the deadline. So there's different deadlines. I know everyone's saying, you got to get it in by this date, and we're going to talk about the deadlines. But whether it's a refund request or an abatement request, the deadline is not just July 10th. But for the straight refund claims, we're trying to push everybody there because we want, what if you don't look at it? What if you wait and then they do have a straight refund claim and you miss the deadline? You want to be looking at these cases way in advance of the deadline, to make sure you're not missing the deadline, right? So here, act now. Wait and see is not a strategy. I am deep, 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 deep in the Reddit threads of tax pro, you know, chat rooms, shall I say. I love to read them. I love to see what people, if there's a big Facebook group for tax pros and tax resolution, and I love to see what people are talking about. And a lot of people are like, well, it could be overturned. Do I really want to do all this work? And we honestly are trying to encourage everyone. Again, Pitbull has made it, you can see who has claims so easily there. I know the work of actually filing the claim and preserving the claim and fighting with the government, yes, that's a heavier lift, but there is no reason not to get it done. And waiting and seeing is just not a strategy. And why is it not a strategy? Because if you wait, the statute of limitation may run on the claim. So even if Kwong gets held up, if the claim is not timely filed on the Form 843 for the 3-year rule, right? So refunds are 3 years from the due date of the return or 2 years from the payment date, whichever is later, you might have an issue, right? If it's a straight refund claim. Now, if it's an abatement claim, we might have after the deadline, right? And we got to, again, it depends on each transcripts when they paid, what rule we're working with, and whether or not they paid the tax or they didn't pay the tax. But for straight refund claims, if you don't file a timely claim by the deadline and Kwong holds up, they lost their right to a refund. It doesn't matter. The government doesn't have to pay them the money. So we don't want to miss out preserving someone's right just because we didn't get it done in time. It is April. We're all busy. Um, but that doesn't mean that we can sleep on this because like I said, in some of these examples, we were showing you there are six-figure savings to a client, and some it's seven-figure savings, and even a five-figure savings is important to everyday working Americans and small business owners. So it's important. I don't know if Glenn wants to take over the employee retention credit.
Yeah, I'll do the employee retention credit. So everyone on the call thought the ERC was over, but maybe it's not. So the tax return deadline generally for the employee retention credit goes by something known as the deemed due date. So 2020 tax returns for the ERC were due April 15th of 2024, 3 years after the deemed due date. So you go to the April 15th, 2021, you count 3 years from that date. April 15th, 2024 was the deemed due date is the RSED date for the employee retention credit for 2020. So the same rationale for 2021, April 15th, 2025 is the deadline that everybody thought for 2021 employee retention credit. Now, under the Kwong analysis, perhaps that's changed. And, I think first off, the big beautiful bill, it killed 2 quarters of the employee retention credit. It killed Q3 2021 and it killed Q4 2021, effective for any return filed after January 31st, 2024. So the Kwong analysis likely won't work for those 2 quarters. And there was also a case that challenged the constitutionality of this retroactive termination of the employee retention credit for those 2 quarters. The first court case of its kind, unfortunately, was dismissed on summary judgment. So as of right now, it looks like Congress likely had the authority to retroactively end those 2 quarters. But what about the other quarters? What about 2020 ERC and Q1 and Q2 ERC for 2021? Under the Kwong analysis, if the tax return due date for these 941 tax returns wasn't until July 10th, 2023, well, it would logically follow that we have at least until July 10th, 2026 in order to file for the employee retention credit. Well, what about deemed due date concept? Maybe, and here's where it really gets unclear. There may be even the possibility of saying, hey, well, you look at July 10th, 2026, what would the deemed due date be relate to 941s? Well, that's always April 15th of the subsequent year. So it's possible you can make this argument all the way out until April 15th, 2027. Now, we know the IRS is going to reject these 941 X's, and they're going to say these are untimely. But, we're advising primarily very, very substantial clients, hospital systems, nursing home systems, health centers. We're advising them that they should file if they feel that they're eligible, and then we'll take the tax controversy on. We'll deal with the initial rejection or disallowance. We'll appeal that into IRS appeals, and then we'll take that case one step further. We'll go to the U.S. District Court, or we'll go to the Court of Federal Claims where the Kwong case was heard, and we'll ask for relief there, and we'll ask for that employee retention credit to be granted at the court level. So that's one implication.
Ready for the next?
All right, one more poll for everybody.
Oh, okay, we're doing a poll.
I'll take it. I think as we cover many complex subjects, it's always interesting to get a pulse from the practitioners on the front line. How relevant has it been in conversations? So we're talking about Kwong, we're talking about how it relates to ERC, we're talking about how it relates to potentially having penalties abated and refunds in certain circumstances. So to the practitioners, how often has Kwong been coming up? Your options are this: not yet, once or twice, or it's coming up regularly. I have a suspicion where we land on this, but am eager to hear from y'all.
Yeah, taxpayers don't know about Kwong. I'm pretty positive, and 80% of our attendees agree.
Yeah. Okay. The result, we have the results back.
I'll share result.
Okay. Yeah. This is no surprise. It's no surprise at all.
Okay.
Awesome.
Let's
Thank you.
continue. Thank you.
All right, I'll take it away with the second ERC implication. And all practitioners were given the advice from the IRS that taxpayers who claimed the employee retention credit, they should have amended their income tax returns the years in question and reduced their wage expense, thus increasing their taxable income. So a lot of people who claimed the employee retention credit were delayed in getting their ERC refunds. And what we saw was a situation where when they went back to do the amendments and say, hey, I received, $2 million of employee retention credit. I'm going to amend my tax returns. I'm going to reduce my wage expense. My income went up another $2 million. Well, the IRS went and assessed penalties and interest on a lot of that. And, under the Kwong analysis, that's a great opportunity to go in and say, hey, the tax return deadline wasn't until, July 10th at 2023. Therefore, a substantial portion of these penalties and interest is not due to my clients. So we're certainly doing a lot of Kwong cases associated with the ERC. And we highly encourage clients who amended their income tax returns to do the same. There's one more slide, I think, Alyssa.
Yes, disallowances of pre-leave refunded credits.
Okay. So this kind of interestingly cuts two ways, so the interest computed. So there's overpayment interest and there's underpayment interest. So this slide kind of addresses the context of underpayment IRS interest. So there were situations where the IRS went in and disallowed quarters or audited quarters of the employee retention credit and said, hey, client, I don't think you're eligible for this. And when, the IRS made the assessment, they assessed it, but they assessed it all the way back to the original due date of the 941. Well, under Kwong, those interest and penalty accruals should have started on July 10th, 2023. So taxpayers can go back and they can get that portion refunded as well. It interestingly cuts the other way under Kwong. This potentially helps the government. So on overpayments, the government's been paying
Alyssa, if you want to step in.
less.
Oh, sorry, let me go back. Uh-oh. There we go. Are you back with us?
Yeah, Glenn, you're muted.
So basically, this slide was just saying that the government could make the argument the other way that they overpaid people interest, right? And so we're going to talk about why legal representation is vital for a Kwong claim. So I'm just going to give you all a few examples because we have been raising this issue. One of our partners, Jessica Marine, was able to actually get a court in tax court, IRS counsel to agree to a decision document that encompasses Kwong. But after, I mean, that was probably like a month ago. Now the national office is being very strict about Kwong. So I tried to raise it. I had a decision document for a taxpayer where we had, gone to tax court. Their original bill was like $200,000 and we got it down to like $50,000. And so I said I would like to sign the decision document. However, I would like, you to consider, changing the language about interest and penalties under Kwong. And immediately IRS counsel came back to me and said, no, due to the national office, we're not conceding to Kwong. We think this law was improperly decided. We plan on appealing it, and we are not going to agree to it. So now that leaves me as a practitioner two options, right? I either sign the decision document and my client gets charged the interest and penalties, and we can talk about what I could do after that. Or I have to go to my client and say, hey, they're not conceding on this issue. Do you want to risk the decision document, the settlement that we have? I can amend your tax court petition and we litigate this penalty and interest issue, but we could jeopardize the settlement that we've kind of already reached. And for a smaller claim, I don't know that my client has the resources for me to do all of that and keep fighting all of that. So again, what the right outcome is, I'm advocating for it. That's going to be up to the individual taxpayer, right? In a tax court setting, I have to go to the taxpayer and say, hey, you get a choice. And another case that Jessica and I are working together, it's a CDP tax court case, right? So we had the collection due process hearing. Um, a notice of determination was made, not in the client's favor. I mean, he owns a bunch of houses and doesn't want to sell them. So we're in tax court arguing over that, but we're also raising the Kwong issue there. And again, counsel is saying national office says this, we don't, you know, we're going to appeal it. And so we have to go to him and say, do you want us to amend the petition and hash it out here? But in that case, it's $200,000. Like how can we not hash it out there? So in the tax court, raising this Kwong issue in tax court, um, the option I talked with another one of my colleagues, Michelle Levine at Denton's, is she believes, hey, you can sign the decision document because the decision document says that under law, they will assess the interest by law. And she's like, I still feel like you can file an 843, an administrative claim um, on the interest adjustment because that is technically by law because there is a court ruling holding that that is the law. So again, it's easy, but it's kind of not easy. It's easy to calculate the difference and to figure out what it is, but to get what we need to get done in order to get the government to accept it, the government's not going to make it easy. They were, I think, wavering on it, and now it's just full stop, hard stop. Even in collection due process appeals, I am raising it and I'm talking to my other colleagues, and so we're getting mixed results. Some people are saying in appeals, they're like, we totally understand you, but again, it's coming from the top. We're not conceding on this issue. We're going to make you fight for it. So if they're going to make us fight for it, we have to be prepared to fight for it. And so if you're uncomfortable fighting on behalf of your clients, you know, taking it to tax court or doing refund litigation or raising it in a CDP and then taking that to tax court, um, it can be helpful to have an attorney because we have no problems hashing this out with the government. I think people are legally entitled to hash it out with the government and they have the right to do so. So that's why we're putting caution here. If you're comfortable filing a claim, get it done, get it in, preserve your client's rights. But do not expect that there's going to be money paid out tomorrow. We all know how the government works. We all know they're behind. I think the more likely thing is two things. They're going to get the 843 and just not respond. I think they're not going to respond at all. They're just going to ignore it. They're going to appeal Kwong, and that's okay because at least you preserve their claim, right? This can go on for years. They could just flat out reject the claim and say, no, we're not going to give you. I feel like even when I do reasonable cause abatements these days, I could have the best story of all time. My client's got dementia. She had a miscarriage. She felt, all the things. They don't care. I don't even know that they're reading them these days. I feel like they look at them and then they deny them. Sometimes even the rejection letters that I get, the denial letters, the language in the letter is clearly a form letter and they didn't even finish filling it in. So I would expect either no answer at all, or you're going to get a denial and you need to file a protest, right? So once a claim is denied, you can file an administrative protest. Even if you've gotten no response at all, right, and it's been 6 months or longer, you can actually sue them in district court or the Court of Federal Claims for a refund, right? And we do a lot of refund suits. That's one of, I would say, Frost Law's main practice areas right now is suing the government for refund claims for ERC. So this would be no different. So having a lawyer on your side or having a partner on that side, we're here to help. But regardless of where you are, filing the claim is important and getting it done, right? So the variance doctrine and current court actions, there are a couple. We'll talk about the variance doctrine just prevents taxpayers from seeking refunds from showing up at court with new or novel arguments that haven't been presented to the IRS. So the facts and grounds have to be included in the refund claim. And if the return is examined or disallowed on appeal, taxpayers have to fully explain their position and identify the law. However, I think the more interesting part of this slide is there are a couple class action lawsuits right now for overpayment of interest, or seeking overpayments of interest. So those are the two class action lawsuits that are currently, sorry, I'm not trying to rush, but I know it's already 2:45. If you want to look up those cases. Additionally, I did want to make sure every time any of our software providers add new things, I think as a practitioner, maybe you get busy, you don't notice that they added it. Pitbull has this right there, and if Irina wants to jump on, and I'm sure she's sent y'all notifications and everything, but it's right there in your transcript dashboard. This beautiful report that they've put together for you. You can see your client's name, the form number, the tax period, when the return was filed, the failure to file, failure to pay, estimated tax and interest payments, and then the potential abatement amount alongside the outstanding liability amount. So I think this report is fantastic. Now we did, discuss that there are lawyers making arguments that are not as solid or as strong as some other arguments. And so the failure to deposit penalties, because it doesn't comply with actual specific statutory deadlines of a due date, this column right here on your right to the far right for the failure to deposit penalties, that is a more aggressive position. Does it mean that you shouldn't take it? I think it depends on having that conversation with your client. As a lawyer, when we take aggressive positions or we take an action, I feel like my job as a lawyer is not to say, we must do this, we must do this, we must do this. I say, hey, here's the opportunities. Here's the likelihood. Here is a great position to take, and here is a less advantageous position, or a more risky position, or one that we're not as confident in. What do you want to do? I personally, and I'm sure Glenn can comment on this, I think we would want to overshoot the claim than undershoot the claim, because if you undershoot the claim, that could give the government another reason to limit the amount of the refund. So I personally think you would rather be more aggressive.
Yeah, I don't think the IRS has the authority to issue a dollar more than what you're going to claim on the analysis on the 843 form. So I would totally overshoot it. Interestingly as well, the IRS is going to pay overpayment interest on all of this as well. So not only are you going to get the interest from the Kwong period, the penalties refunded, but there's going to be overpayment interest on all of that that's also issued. So I would shoot for a higher number.
Just to be safe. So
Real quick, another poll was launched.
great.
So I think here it's just getting a sense of, we're talking about Kwong, we're talking about an opportunity where client bases would have been impacted. Everyone's going to fit into the supporting cast differently. And let's be candid, everyone is busy. So the topic here is, are we actively helping clients with Kwong related claims? No, I don't have the bandwidth, not yet. I'd like to, haven't started. I'm interested, but not equipped to handle the administrative appeals. So what happens if the government says no, no, no? Or I'd prefer to refer these to a specialist and share in the fees. Someone belabor me from this. And then maybe we give it a minute, we see what the results look like, and then we can move to what steps need to be taken to do this correctly.
Okay, here's the results.
Okay. No bandwidth. We get it. Vacation time. Not yet. Haven't started. Want to. I'm interested. Not equipped to handle appeals. I prefer to refer these to a specialist. So no matter how you fit in, the aim for us is quite simple. It's arm smart people with good information, and then be supportive where it's helpful. And so no matter how you fit in here, the goal is to be resourceful. And thank you. We can close that now. And then, Alyssa, if you just want to go into maybe some of the best practices what needs to be done, instances where when these steps are missed, what does the consequence look like? So for practitioners and folks supporting clients who this is applicable to, where are my red flags? What do I need to look out for? How do I do this right?
So one of the most important things is an 843 has to be filed for each tax form and each tax period. So you cannot aggregate claims on one form, right? So each one, like let's say we've got, 19, 20, 21, 1040s, and then they have, other, let's use a business case, so same taxpayer, keep it simple. Let's say we've got 19, 20, 21, 1120S, penalty abatement. So we need one for each 1120S, and then we've got 6 quarters of 941s, right? Each one of those claims needs its own 843. Cannot aggregate them, right? Each one needs to be printed out. And this is really important. I was talking to a practitioner the other day that has some software, and they were like, well, we're just going to let the taxpayers digitally sign the 843s. And I was like, I
No,
feel like
no, no,
that's
no.
not good. And they said, well, we'll have them on file just in case. And I said, no, no, no. It doesn't, that's not valid, right? And so wet ink has to happen, right? I was surprised that that person was even bringing that up. I was like, that is risky. I would not do that. I would even say blue ink, okay? Because even I have a really, I think, nice signature. And sometimes when I send stuff to the government, they're like, this is a robot. And it's like, no, that's just, I write in cursive really pretty. I don't know how else to prove it to you. So blue ink is beautiful. Blue is blue. Wedding signatures, each one. Now, if it's a joint claim, right? You need to have the taxpayers both sign the 843. There are situations where we've got people that are divorced or they're no longer together. I would try your best to get them both to sign the form, right? Especially in a case where they're getting a refund. You want to make copies, obviously, and anything we send to the government these days needs to be certified return receipt,
Excuse
right?
me, Alyssa, let me interrupt you. Do you recommend representatives with a valid POA to sign 843s?
They can, but I recommend the taxpayer having them because I don't think just the practitioner signing themselves, I would be concerned if there's an issue with the POA. I mean, you can attach it. I think to be as safe as possible, having the taxpayer sign it is a better play because we don't want any processing issue or any issue with your POA because we've even had that with CDPs before. So could the practitioner with a valid POA? I think you want to have the taxpayer sign it in this case.
Okay, thank you.
But you can sign it as a preparer, right? There. But I would definitely in this case I wouldn't risk it. I'm having all my clients sign them originally. Like I'm emailing them out to them, sign them, send us back to it, we'll send it for you. And then
Glenn, oh, I'm sorry, Glenn, did you have something on the tip of your tongue?
Yeah, and we've seen a lot of employee retention credit claims, 941Xs rejected on that basis that there was electronic signature or a DocuSign signature. Also on some of the business returns, the wrong title, a title that's not, strong enough, president,
I did.
officer of the company, et cetera. So there's very specific titles for the corporate forms. But with regard to the return preparer, yes, you must put your return preparer information on the form, but I don't think the return preparer is required to have an ink signature. But the taxpayer is.
And then for certified mail, the IRS has never lost a single form ever. But if they do lose a form, it's important that you have your receipts. And I know that everyone on this call has dealt with the migraine of how many times do I need to mail the same form in for it to get lost somewhere in the shuffle. So Alyssa, if you want to pick up on just, I think I hit it there, but certified mail, critically important.
It
Hold.
is, and I know it's annoying, but again, the government loves denying things for any reason they can find. So ideally, you send a certified return receipt per form. I know that's a heavy lift, but if you want to be extra safe, you send each one by itself with its own certified return receipt. I know a lot of practitioners put it on one cover letter and say this is included and here's the receipt and have a scanned copy. Um, I don't think one or the other is particularly, I don't think the secondary is wrong. I just think it depends on what level of safety and proof that you want, right? So that it is what it is. If you want to be extra safe, you can send them separately with their own certified tracking receipt for each tax period and tax year. Because, a lot of times, this is the other, I think, messy thing about refund claims and why, they're such a pain is because each period and form stands on its own. Oftentimes, you'll get different responses per period, and then you have all these different appeals or protests out there, right? And you got to manage them all, right? Because they don't like for the ERC, right? We would have like 8 different quarters, right? That we would be getting letters on. One got a protest, one got approved. So it can be a mess, I think, administratively or procedurally to keep up with if you're not used to doing that. So that's another thing to consider. It can get really tedious. Um, Mailing to the correct service center. Obviously,
Alyssa, sorry, forgive me, jump ahead 2 slides because there's specificity in regards to this topic.
okay.
So,
Oh, yeah, we did the certified mailing retreat,
yep.
right? Mailing to the correct service center. So obviously, it's based on where the taxpayer files. So you want to make sure you send it to the correct address. Again, addresses can change. So, this is what it is today. And obviously, you want to save all of your documentation. I'm going to let Glenn or Skylar, take over
Yeah.
this portion of our presentation. And you want to take it away?
Yeah, perfect. So Irina has done such a fantastic job arming you with good data. So it's truly a round of applause to her and her team for setting you up for success. As Glenn and many practitioners and Alyssa, you've tried different softwares. It's really nice to be in the hands of someone who goes out of their way with no purpose other than how can I bring value? And the reality is the platform that she has set up makes this so much easier for you. So I would access the page, get familiar, see who it's applicable to, and there's really a big opportunity to bring value. How we're working with folks like you, we did just describe. Here's the facts. The government makes things challenging. The process to get this done is tedious. We can't ignore it, but we also can't ignore the opportunity to be helpful to clients. And I think it's a balancing act with staying sane and doing everything you can to represent your clients the best way possible. What we're doing for folks in your shoes, if you do not want to handle some of this mess, we're stepping in. And as an Arizona law firm, it's a bit unique at Frost Law Arizona. We have the ability to share fees with non attorneys. So, in instances where you get to your portal and you identify that there's a claim of $75,000 or more, and it looks as though it's going to be a refund to this client of yours, we do not mind doing all of the lift, preserving the statutory rights, making sure that the files get submitted accurately and timely. In the event appeals are necessary, going into those appeals and fighting diligently. And then if complaints in the court end up being the remedy, well, that's why we're here. In doing so, we share 20% of the recovered fee with y'all. So, the idea is mailbox money for you, help clients create an environment where everyone wins. So here are some parameters. What I'd say is you'll get a copy of this presentation. At the very least, everyone should go to that tab, get familiar with your book of business and how they fit in to Kwong. And then where there are instances of congruency, we've put a intake contact in this presentation you can find. It's as simple as an email. You guys want the help, we're happy to help. Let's make an intro. Let's make sure you're compensated for that effort in the intro and work together really to provide the best possible outcome for our clients.
I also want to mention, I think the goal here is to get as many practitioners to help their clients get a claim filed, however they have to do it. Like we're all working together. Every tax attorney I know is like posting information on this. Frank Agostino's got some really great, 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 like 30-page like dissertations analysis of different ways and different ways you can raise it. So we're all here to help. And I think, the government is expecting all of us to be too busy or taxpayers not to know what to do. And we're all here to help. And I think we can do that service by getting as many claims filed as possible.
And two things. So a poll launched, and I missed one detail that's going to be helpful too. So how many Kwong claims have you filed so far? We've gotten much context from previous polls, but would be curious to see. So a quick launch of the poll. Thank you. Um, and then we'll give it maybe 10 seconds and can close that out.
Mm-hmm. Yeah, let's wait a little more. So far, I see that people did not file any Kwong claims.
And again, the importance is make sure that you've completed 3 of these polls. So if you haven't, this is a good opportunity to make your selection. Alyssa, go back for me just one slide quickly. Okay. Yeah, none. No problem.
Oh, now I can see the polls. Hold on 1 second.
Go back.
91% didn't file any claims yet, 7% 1 to 5, and only 2% 6 to 20, and 1% over 21 claims.
So maybe back arrow will do it.
Yeah, there you go. Sorry.
Okay. So there's a self-file option if the claims are under 75,000 for refund, covidtaxrefunds.com. It's a flat fee to have the forms prepared. Again, we'll make sure you have this copy and you can reference it if helpful. Finally, let's round out with some thank yous and how to get in touch if you want to.
Perfect. Thank you so much, Alyssa, Glenn, Sadler. Thank you so much for a great presentation. I'm sure the opportunity is great and you see the numbers. So go to your transcript dashboard, update it if you haven't pulled transcripts recently. All the data will update automatically. You just need to see. And your clients will be listed from the highest potential abatement opportunity to the lowest. And then you decide whether you want to file a claim yourself. Remember, the deadline is July 10, 2026. Or you want to hand it over and refer it to Frost Law. Just a quick note, we are not affiliated with Frost Law. We are not getting any income of that share, so it's between you and Frost Law only. And I want to have some time if we can go over the questions. I selected some to answer live. So, first question, what if they already owed payroll taxes for 2018 and 2019, but the penalties and interest for those years were charged or posted between 2020 and July 2023? Would they qualify for the Kwong abatement?
You want to answer that, Glenn, or you want me to answer it? Okay, so for 18, I don't think because it was assessed in 2021, I do not believe it would be abatable under Kwong because if 18 was due in 19, right, then it wouldn't be within that Kwong window. Now, that's where some people are making the interest accrual abatements on periods outside of the Kwong window. And I think that is a lesser established, or I don't know, not as good of a claim as a period where the due date and the filing date actually falls within the Kwong period. Glenn, what are your thoughts?
Yeah, some practitioners are saying that interest should have been told during this time frame and that it's worth a shot. And some people are making the argument. So we'll see as it develops. We don't know, I think the important thing to know is that right now the IRS has not taken a formal position on any of this. They're unlikely to take a formal position on any of this until after July 10th. And, you can file to preserve their rights. So if you think that that's a good argument, it's probably worth a shot. The only thing you have to lose likely is time. So
yeah, and the size of the claim, I think it kind of, really, really depends on the size of the claim. And I think when they're outside of that Kwong window, the savings really drastically declines. you're not, the more you're within the Kwong period, the more savings you're going to have. And again, 19, depending on the size, is generally going to be bigger because that's generally the longer time frame of interest and penalty accruals to me, I think. But it depends on the facts and circumstances.
Let's give it
Alyssa.
to Irina to next question.
Okay, I have a question for Glenn. So if I understand, if the client amended returns after ERC funds received, they can claim a refund of interest and penalties and ask for the refund of these even if they filed in 2023 or 2024.
You're on mute, Glenn.
Yeah, that's right. So, if so the instruction from the IRS was to amend your income tax return to reduce your wage expense for tax years 2020 and 2021. And many taxpayers waited to do that until after any tax, deadline, right? They didn't do that up front by the actual deadline. So the IRS assessed penalties and interest after each of those respective income tax deadlines. So the window of time where now the deadline has been pushed back, all those penalties and interest should be abatable under the Kwong analysis.
Perfect.
Refundable,
Thank you so
yeah,
much.
yes, they paid it.
And because of time, we'll take one last question. How would one apply for Kwong where the taxpayer filed a CDP request regarding penalties before Kwong was decided, and as such, made no Kwong arguments in the request, but simply asked for collection alternatives?
Have they held the CDP hearing yet?
I don't know the answer. It's a question from the
Okay.
audience. So
I
if
would
not,
if not, because I too filed quite a lot of CDPs and I did not initially make the Kwong arguments. However, even if I've already had hearings and even if I haven't had the hearing yet, I am then sending the information to the appeals officer in cases where I've already had the hearing. I'm like, and we haven't done the formal resolution. I'm raising it. I'm sending the email and saying, hey, I think they have a Kwong for claim, a Kwong claim. I'm also sending the 843 to the correct service center, right? Because sometimes appeals doesn't have control over the period that you're asking them to make a decision on in a penalty case. Like maybe you only have an appeal on 2019, but they got a 2020 Kwong claim. I would still recommend filing the 843 for all periods to the right service center, send the appeals officer a copy and raise it there. And just because you didn't put it on the 12153, I'm still raising it. Why wouldn't you?
perfect. Thank you so much. Thank you, Alyssa, Glenn, Sadler, for a very amazing presentation. So a lot of knowledge, and it's time to go and work because we do not have much time left. You decide which clients you want to pursue this with. Look at your transcript dashboard. And by the way, if you do not have access to transcript dashboard because you do not have IRS transcript delivery add-on, today only we offer 20% discount on this feature. So call the office 954-748-2855 and get this added because you need to see which of your clients qualify for Kwong penalty abatement. And it's time to work, guys. Thank you so much. The session will be recorded and posted to our website. And I'll see you soon at our next webinars. Thank you.
Thanks, everyone.